Today's episode is brought to you by Forvis Mazars.
SoundCartel.
From SoundCartel, I'm Nicole Goodman, and this is Business Essentials Daily. It's hard enough chasing clients who pay late, but what can you do if a client doesn't pay at all? For a small amount, it might not be worth the time and resources, but if it's worth thousands of dollars, how can you get it back? Well, it's not easy, says Paul Cott, principal lawyer at Law on Lydiard. You could go all the way to court and win the case and still have to wait, depending on the recalcitrance of the payee. So Chris Ashmore asks Paul, what steps can a business owner take to get their money?
So they're obviously going to send reminders, send follow-ups, send statements, maybe even make a phone call, send emails saying, your account is so many days behind, what the trading terms are and so forth. Then I guess you've got a debt collector. That's one option. Some of the debt collectors you can engage do no win, no fee, so they don't collect anything that you don't pay them. You can get a lawyer to call, you can get a lawyer to write a letter of demand, and I guess you're going up the chain of the formalities, and after that, I guess you've got court action, which should always be viewed as a last resort, because obviously it costs money.
Well, a lawyer costs money, and provided you go through those first steps of trying to work it out yourself and then the debt collector, when should you approach a lawyer?
Probably, and it might be surprised some to say this, but probably as a last resort. If all your other options haven't worked, I sort of put debt collectors and lawyers as to recovery of debts around about the same footing, as in you might be looking at a lawyer, but maybe you just try it with a debt collector at the same time or instead of or as well as. But really, that's an escalation of the matter. You've tried all other avenues to get the debt paid, and there's been no success or no response. And sometimes the reason for the non-payment becomes apparent, even though you might have suspected what it was before, and that is that there was some defect or some problem with the quality of the work or the good of the service that was provided. So it's probably then, as an overall proposition, to say that's when you get a lawyer, because then they can deal with those issues of alleged underperformance, as to the works or the defect in the goods.
And what can a lawyer do?
A lawyer can write a letter of demand. If you are going to escalate it to a court or a tribunal, that court or a tribunal will probably have expected you to have a lawyer write a letter of demand, because that's really, I guess, putting the screws on, putting on the pressure to say, pay up within 14 days or 21 days or 28 days. If you don't, we're going to go to court. It's
worth doing this when we're talking about a lot of money. If it's just $50 or $100 or whatever, that's probably not worth the time spent with a lawyer or your angst getting that money back, right?
Yeah, true.
We're talking about probably thousands of dollars.
Yeah, probably really as an informal, unofficial guideline, anything above probably $2,000 or $3,000, you might engage a lawyer. I've always had in my mind that I wouldn't issue a debt recovery proceeding in a court or a tribunal for less than $10,000. As a general guide, because the legal costs that can mount up will not make getting a lawyer and issuing court proceedings for that amount efficient.
Mm-hmm. If you do engage a lawyer and you go to court, what do you need in terms of making your case? You need proof of purchase and all these kinds of things?
Yep, evidence, tax invoices, the receipts of payment, evidence that the things were provided, quotations, contracts, the copy of the agreement, copy of the communications between the parties. That's right. You need all the evidence to back up your case, just as any other court case.
How long does it take from the time you go and see a lawyer, it goes to court and resolution is made?
So there's a series of state-based tribunals around Australia. I can only speak to my experience in VCAT, the Victorian Civil Administrative Tribunal, is actually slower than a court. You probably look at getting a hearing and a mediation in between in a court probably about a year, maybe even less, depending on, usually it's in the magistrate's court if it's $100,000, whereas in VCAT, you're looking at a year to 18 months, or state-based tribunals, maybe about a year to 18 months, maybe even a bit longer.
Wow. Now, if you do win the case, it goes to court, you win the case, when can you expect to get the money back from the person who hasn't paid?
Well, that's the big battle, is that going to court and winning is only half the battle. It doesn't get the dollars in your bank account, so to speak. You may need to take further steps. You may need to incur further costs. Now, those costs do get added on to the judgment debt, as does interest at the penalty interest rate, which in Victoria at the moment is about 11.5%. There's no guarantees. There's not a 100% guarantee that you will get paid. It might be that you, as a last resort, seize the person who owes you money their assets, and you can't seize any assets. They don't own anything. They don't have any income. You can't get a warrant and seize and sell their property, and it can all be a pointless exercise. In the minority of cases, that is. Usually, to be honest, you'll get something. The question is how much. You might get 3/4 of the amount. Most cases settle at mediation. You might get half of the amount that you originally seek, and then you might just cut your losses and finish the matter then and there.
In the majority of cases?
Yeah.
Why wouldn't you get 100% back?
Because if the debtor still refuses to pay, even after a court win, you have to go to look at what are the enforcement options. You might send a letter to BAN saying, we won in court, here's the judgment, here's a copy of it, if you haven't got it already, which they probably do, pay up. And they ignore it still. And you think, your clients are exasperated saying, we won in court, we've got a judgment, and we're still not getting paid? What's the go? Mm-hmm. The debtor could still be refusing. So you have to turn the screws up, so to speak, in using one of these enforcement methods. So winning in court and getting a judgment in your favour is honestly only about half the battle.
Wow, okay. There's a term, attachment of debt. What is that?
So that's where, if you know that the debtor is owed money from someone else, you can intercept those funds, or attach the funds is the technical term, so that when that person pays the debtor, those funds go to you instead. It's an order of the court. You apply to the court on application with an affidavit, setting out what the situation is that the debtor is not paying, and then those funds that would otherwise be paid to the debtor go to you. The problem is, though, is that you often don't know the debtor that well enough that you know that they're owed money by somebody. So, for example, you might sue a landlord where you know he's going to get rental payments, but you might not have that information. Also, who's paying the rental payments? Who are they? What's their address? So even that option is not foolproof, and that's why early on in the process, once you get a judgment debt in your favour, it's a good idea to issue a summons for oral examination, because it gets the debtor to fill out some paperwork, get them to appear in court and answer questions under oath that sets out their financial situation. Then you get a suite of information. You have all the information that you require to use the best method of enforcement. On that document, presuming the debtor's telling the truth, they'll list who owes them money. So then you look at that and you'll potentially then utilise some of that information to intercept that debt. Wow.
Another bit of legalese, instalment order. What's that, Paul?
Again, that's an application accompanied by a stat dec or an affidavit that is an order of the court to say that the debtor should pay a certain amount in instalments, including costs and interests, so that the debt is paid in full. The court will make the judgment based on the material that's filed as to what the debtor can afford to pay. Mm-hmm. And the court will utilise the financial documents that the debtor provides to work out, for the court to work out what an appropriate amount to order and over what period of time. Obviously, sometimes I've had situations where the debtor says, well, I can afford to pay $20 a week. But then on the financial information, the court can say, no, it looks like he can pay more than that. But they're not going to order anything like 50% of the debtor's wages or income. They're usually capped at 20%.
But can't the two parties sit down and negotiate and come to an agreement between themselves when and if the person can pay in instalments over time?
Yeah, an instalment agreement. I mean, that's probably a cheaper way to do it, and it's got the advantage that the debtor has agreed to it. Hmm. The disadvantage is that the court hasn't ordered it. So
it's not enforceable?
it is enforceable, but the debtor might regard it as being less enforceable because he's saying, well, I agreed to it. It's not a court ordered, so it's not compulsory. But it is actually registered in court, so it is quite enforceable. If you breach it, you can then say, I want an instalment order now, or utilise another method of enforcement, such as seizing assets and selling them to pay the debt.
Right. Well, there are various enforcement options, Paul. What would you say is the best?
In my experience, if the debtor owes you money and they are a wage or salary earner, you garnish their wages. That's the best method. In my experience has been. The problem is that it only in instalments over time. It's actually a court order. You apply again for an order of the court, but they're not allowed to deduct more than 20% of the debtor's wages. So they've still got to live while they're paying that back. The problem is, as before, is that you need to know where the debtor works. You send that documentation to the employer. The employer has to abide by the application. And if it's an offence not to, they'll automatically deduct that amount of wages out of the person's wages before they get it. And the second problem with that is then the debtor changes their employment and they don't tell you where they've gone. So then you say, well, that old employer can't deduct any more wages anymore, so you've got to start the process again. But there's that one. And also, if you have information on the title search that the debtor owns real estate, you can. It's an extreme measure, but it is available. Apply to the court for what's called a warrant of seizure and sale of land, and you could potentially, I don't know how often this is done, potentially then have their property sold. And you'd only be looking at that process for large amounts, $200,000, $100,000 and so forth. You can apply, and it's a bit of a costly, slow, cumbersome process. You can apply for an order of the court that land gets sold and the proceeds get paid to the debt, and the debtor would then get any surplus over the amount of the debt. They're probably overall the two best methods.
That was Paul Cott, Principal at Law on Lydiard. This episode is general information only. It may not relate to your particular circumstances. If you need specific advice, please consult a lawyer. This episode of Business Essentials Daily is produced by the team at SoundCartel. Thanks for listening. I'm Nicole Goodman. We'll bring you more Be Daily tomorrow. Follow at BE Daily Podcast across social media and head to bedaily.com.au for more from the Business Essentials Daily podcast. SoundCartel. This episode was brought to you by Forvis Mazars. To find out more, visit forvismazars.com/au. That's FORVISMAZARS.com/au.